everyone, and welcome to Crime in Court. This is the 1993 Menendez brothers trial. We have watched the entire trial now, and we are picking up kind of afterwards where we're continuing on with the court proceedings. We're going to be going through some of the court documents and so in today's stream, and I apologize that I did not get to this last week. It was with the holiday, I just didn't get to it. And I realized that I had more documents that I didn't have. There were more documents that I needed to download. And in that, I realized that there are a ton of exhibits that are very relevant. A lot of it has, there's a lot of affidavits and things like that from the brothers, from people that knew the brothers. So I really think it's important to read through those. So this is going to be a two-part episode. We're going to read through first in today's episode, we're going to read through the habeas corpus appeal from the brothers, which was filed in where was it? 20 May 3rd of 2023. We're going to read through that, and then we'll also read through the latest filing from the DA. They're basically asking for more time, which is ridiculous because we'll get into that. But anyway, so we'll read through that. And then in part two, we will read through all of the exhibits because I think they're really important and relevant. So we'll get to that. So, up first, actually, before I even get to that, please hit the like button as it helps the algorithm. Um, all right, so first I want to talk about what is habeas corpus. So, this term is thrown out all the time in, court shows and whatnot, but what does it actually mean? And this was one of the simplest definitions I could find out there. So, habeas corpus is one of the earliest common law writs. It is, in its simplest form, a writ of habeas corpus requires that a person who is in custody be brought before a judge or the court and that they be able to challenge that custody. So, I'm in custody of the Department of Corrections. I need to go, I want a writ of habeas corpus so that a judge can look at my case and say, okay, maybe your sentence is inappropriate or you were illegally arrested or whatever, whatever it might be. So that is what you would be asking for the writ of habeas corpus for. And so habeas corpus is used to attack an unlawful detention or an illegal imprisonment. So whatever reasons, there's a number of reasons, just um, why someone might be illegally detained if there's, wasn't uh, procedure wasn't followed, or maybe there was some bias there, or whatever it might be. So, and that's the attorney's job to lay out in their petition for a writ of habeas corpus. So that is where we begin. So this is from Erik Menendez, the petitioner on habeas corpus, and Lyle Menendez, also a petitioner on habeas corpus. Introduction. A single question. In April 1993, brothers Erik and Lyle Menendez were charged with first-degree homicide in the shootings of their parents, Kitty and Jose Menendez. There were two trials. The first trial began in June of 1993, the second, which we know ended in a mistrial. The second began in October of 1995, ended in 96, which is when they were sentenced. The theory of defense at both trials was straightforward. Neither Erik nor Lyle denied the shooting. Instead, the crime was manslaughter, not homicide. The homicides occurred in imperfect self defense after a lifetime of physical and SA from their parents. The SA began when the brothers were just children, and along with the SA, there were threats to take the brothers' lives should that treatment, the maltreatment of them, be disclosed. Thus, in determining if this was an imperfect self defense case of manslaughter or a case of premeditated first degree homicide, jurors had one critical factual question to decide. Were Eric and Lyle victims of SA? I'm going to stop just to highlight that. After watching this trial, I have no doubt that they were, but that was for the jury to decide. The state theory in both trials was also straightforward. Eric and Lyle were lying about the SA, saying it never happened. They had taken their parents' lives not in imperfect self defense, but to inherit their parents' money. There was never any proof of that, but that was what they went with. And they also tried to bring that to a grand jury, and the grand jury denied um, trying to charge the brothers with some kind of crime to inherit the money as the motive, at least. I don't know what the actual statute was, but they decided against it. So, although the theories were the same in both trials, the evidence at the two trials was very different. And we've talked about that. So, a lot of the talk about SA did not come in to the second trial. There were different rulings that happened. The same judge, different prosecutor, and the judge decided against having any of the SA experts coming in, which, as we know, like there were many, many weeks dedicated to the SA experts because uh, Leslie Abramson and Jill Lansing knew that they had to, in fact, spell out the effects of trauma because at this point in time, people were not talking about male on male SA, especially father on son. This was not something that was readily talked about in the media. And so just the fact that this trial was even streamed and this was one of the theories was wild. And of course, the media took off with it and made fun of the brothers the entire time. And it was awful the way that they were slandered back then. And people are still continuing to try to do it now. And it becomes really exhausting trying to explain to people on the internet what trauma can do. Anyways, let's keep going. So, although the theories were the same in both trials, the evidence was very different. At the first trial, for example, Lyle's older cousin, Diane Vandermolen, testified that when she was 16, she stayed at the Menendez home for the summer. One night when Lyle was only 8 years old, he came into her room and asked if he could sleep in her room. He was scared to sleep in his own room because Jose Menendez was touching Lyle's genitals and forcing Lyle to touch Jose's genitals as well. Diane told Kitty, who angrily dragged Lyle upstairs by his arm. So you go and you tell the mother, and this is the mother's reaction. She gets mad at the brother. She gets mad at both of them, and she drags Lyle by the arm upstairs. Eric and Lyle's cousin, Andy Cano, testified that when Eric was only 13 years old, he swore Andy to secrecy and told him that Jose had been massaging his genitals and asked if Andy's father did the same. And this was testified to by Andy and by Eric, and both versions seemed to match. All right, so similarly, jurors heard from family members, close friends, and a variety of coaches. Oh, I forgot to read this very long footnote. Petitioners no longer have access to transcripts of the first trial, which resulted in a hung jury, but a video of the first trial can be found at the Court TV website. The video of Andy Cano's testimony from October 12th, 1993 is at this link, which was last accessed on 2/1/2023. Because of the length of the first trial, the video is divided on the Court TV website into 121 separate electronic folders numbered 1 containing opening statement through 121 containing a discussion regarding a retrial after the juries were unable to read the verdict. The video containing Andy Cano's testimony is in folder 68. So they're giving them, it's difficult to navigate to, they're giving them the directions to get there. Mr. Cano is called at the 2-hour, 17-minute, and 20-second mark of this video. The sites provided in text are sites to the time at which the reference quote can be found. Thus, the site to 2 hours, 25 minutes, and 11 seconds to 2 hours, 28 minutes, and 4 seconds refers to the portion of the examination occurring between the 2-hour, 25-minute, and 11-second mark and the 2-hour, 28-minute and 4-second mark of the day's testimony, aside from record references to the first trial contained in prior briefings on file with the reviewing courts. Similar cites to the first trial will be made throughout this document. Fine. All right, so similarly, jurors heard from family members, friends, a variety of coaches, and teachers who described numerous incidents of physical and mental that they saw the brothers suffer at the hands of their parents, ranging from physical assaults on the boys to public humiliation and mocking. And jurors heard about a chilling rule in the Menendez home. When Jose Menendez was in the bedroom of one of the boys, no one was allowed to walk down the hallway past the bedrooms. The hallway with the bedrooms, both of the brothers' rooms, was off limits if Jose was in one of their rooms. So that alone is pretty suspicious. So while it is fair to say that the prosecutors at the first trial remained skeptical of the defendant's claims of SA in light of the evidence actually introduced as to SA and physical A, they hedged their bets. If you believe in the essay that happened, that does not mean the defendants are not guilty of M because they are two separate things. We do not execute child molesters in California, and these defendants cannot execute them either. Vigilantism is something we cannot tolerate because then what happens? What if you decide your neighbor is a child molester and you go take your neighbor out? Well, I'll argue that it wasn't vigilantism and they weren't doing it, in revenge. They were doing it for self-preservation, which is a whole different thing. And therefore this shouldn't have really, it's not a fair comparison. It's not a fair argument. Although defendants were tried together at the first trial, they had separate juries. After lengthy deliberations, the jurors in Lyle Menendez's case were hung 6-6 between homicide and first degree and manslaughter for each of the two charges. The jurors in Erik's case were hung 6-6 between the same things as to one of the counts and 8-4 between and manslaughter as to the second count. The state elected to retry the case. As noted, the second trial began in October 95. At this trial, much of the defense evidence, including Diane Vandermolen's testimony, was excluded. So the prosecutor's emphasis changed as well. Based on the evidence presented at the second trial, there was no longer any need to hedge bets. The prosecutor told jurors that the SA allegations in this case were a total fabrication, and that is coming right off of the transcript. Whoa, that was crooked. Let's try that again. Real crooked. So that's coming right off of transcripts from the second trial, and we don't have that in our possession. I don't know if it's out there. I'll look and see if it is. I'm not reading through the whole trial, but I'll see if maybe there's some portions that we might want to read through. If their transcripts even exist out there, I'll do some digging, but that'll be future related. All right. So there was no way of corroborating these allegations. The abuse never happened. There is no corroboration of SA. The allegations of physical and SA are not corroborated. Jose Menendez was not the kind of man that would be A-ing his sons. He was restrained and forgiving. He was not a violent and brutal man. That's coming from the prosecutor in regards to some arguments, I'm assuming closing or opening arguments. He was restrained and forgiving. He was not a violent or and brutal man. Both petitioners were convicted of first-degree homicide. Well, of course, because you didn't bring any of the SA stuff in. But now, new evidence has surfaced in two areas. First, Jose Menendez's sister, Marta Cano, and then she's the mother of Andy. She discovered a letter that her son Andy received from Erik approximately 8 months before the August 1989 shooting. As noted above, Andy had testified that Erik told him about the molestation when Erik was 13 years old. In his closing arguments at the second trial, the prosecutor, told jurors in no uncertain terms that Andy was lying. How do you know that? But this letter to Andy corroborates the SA allegations. Although this letter is discussed in much greater detail below, in it Erik conveys chilling information to Andy. He says, and this is part of the letter. We'll read through the full letter in part 2, but this is just a portion of it that they want us to read. And this is the relevant portion. So it says, I've been trying to avoid Dad. It's still happening, Andy, but it's worse for me now. I can't explain it. He's so overweight that I can't stand to see him. I never know when it's going to happen, and it's driving me crazy. Sorry, bad handwriting. It's driving me crazy. Every night I stay up thinking he might come in. I need to put it out of my mind. I know what you said before, but I'm afraid. You just don't know Dad like I do. He's crazy. He's warned me 100 times about telling anyone, especially Lyle. But there is more. As the above quotes from the prosecutor's closing makes clear, the state's theory was that Jose Menendez was simply not the kind of man who would a children. He is not a violent and brutal man, but restrained and forgiving. What we now know, however, is that in fact, Jose Menendez did essay his children. He aided his children in many, many ways: physical, mental, emotional, verbal, the intimate way, as many ways as you can possibly think of, psychologically, all of that brutality of his severely aid those kids. All right, so Jose Menendez was a high executive at RCA in the 1980s. During that time, RCA signed Menudo, a Latin boy band. Roy Rossello, who joined the band as a 13-year-old in 1983, had just recently come forward to admit that he was anally ard twice and orally copulated by Jose Menendez when Roy was only 13 or 14 years old. And we will read through his affidavit in part 2. That'll be Thursday. Promise. All right. So in short, the new evidence that not only shows that let's start over. In short, the new evidence that not only shows that Jose Menendez was very much a violent and brutal man who would indeed essay his children, but it strongly suggests that in fact he was still A-ing Erik as late as December 1988, just as the defense had argued all along. They weren't lying. They weren't lying. There is evidence that corroborates this. These issues will be discussed below in the attached memorandum, but it is important to note that at this early stage of the proceedings, this court is not tasked with making credibility assessments or deciding if relief is required. Instead, the court has a much simpler task. It must assume the petitioner's factual allegations are true and assess whether petitioners have established a prima facie case for relief on any of their claims. If so, an order to show cause should An order to show cause should be issued, and the state should be required to file an answer to the petition which formally admits or denies the factual allegations of the petition. As discussed in the memorandum which accompanies this petition, following Duval's mandate to assume the truth of the factual allegations of the petition, petitioners have established a prima facie case for relief. To resolve this case, jurors had to decide a single critical question: was Jose molesting his sons? Jurors making this determination did not know of Erik's letter to his cousin, Andy, and they did not know that Jose had previously done similar things to a 14-year-old boy. An order to show cause should issue that being Roy Rossello. An order to show cause should issue that the state be required to file an answer to the petition. So, as noted above, petitioners no longer have access to a transcript for the first trial, but for the court's convenience, a PDF of transcripts from the second trial has been attached on a DVD. So there are transcripts out there for the second trial, but I don't know if they're accessible publicly. I'll look for them. All right, continuing on. Petition for writ of habeas corpus. Jurisdictional allegations. Petitioners Erik and Lyle Menendez filed this petition for writ of habeas corpus. By this verified petition, petitioners allege as follows. Petitioners are unlawfully confined by the California Department of Corrections and Rehabilitation pursuant to a judgment of the Los Angeles County Superior Court in the People versus Menendez. Petitioners were each convicted of 2 counts of first-degree homicide with lying in wait and multiple homicide special circumstances allegations and 1 count of conspiracy to commit M. The trial court imposed consecutive life without parole terms on each defendant for the charges. The trial court stayed the 25-year to life term for the conspiracy charge, meaning that he waived it, he stayed it, he got rid of it. I don't know. All right, next, petitioners pled not guilty. They were tried by jury. Petitioners appealed their convictions to the Court of Appeals, Second Appellate District. On February 27, 1998, the appellate court affirmed the convictions in an unpublished opinion. Petitioners each filed timely petitions for review in the California Supreme Court, which was denied on May 27, 1998. On October 5th, 1998, Lyle Menendez filed a habeas corpus petition in the state Supreme Court. That petition was denied without comment on March 31st, 1999. On April 30th, 1999, Erik Menendez filed a habeas corpus petition in the state Supreme Court. On July 28th, 1999, that petition was denied without comment. Both defendants filed habeas corpus petitions in federal court, which were denied. As to the matters raised in paragraph 6 of this petition, no other petitions for writ of habeas corpus have been filed. Petitioners have no adequate remedy at law. Claims for relief. Petitioner's judgment of conviction has been unlawfully and unconstitutionally imposed in violation of his constitutional rights as guaranteed by the state constitution as well as the 5th, 6th, 8th, and 14th Amendments to the United States Constitution. Newly discovered evidence directly supports the defense presented at trial and just as directly undercuts the state's case against petitioner. The following facts now known to petitioners support this claim. On August 20th, 1989, Jose and Kitty were shot and KILL. In April of 1993, the state charged petitioners with 3 counts, 2 counts of special circumstance homicide and one count of conspiracy to commit homicide. At trial, petitioners did not deny the shootings with which they were charged. To the contrary, as defense counsel explained in an opening statement made before the state even began its case in chief, petitioners admitted their participation in the shootings. The defense was that the shooting was an imperfect self defense. Petitioners did not harbor the mental state needed for first degree homicide and were therefore guilty of manslaughter. Petitioners were tried twice. At the first trial, petitioners had separate juries. At the first trial, jurors heard testimony from Diane Vandermolen. Diane was the niece of Jose and Kitty Menendez, who stayed with them during the summer of 1976 when Lyle was 8 years old. She testified that one night, 8-year-old Lyle came down to her bedroom and asked if he could sleep in her room because he and his dad had been touching each other in the genital area. When Diane immediately told Kitty about this, Kitty dragged Lyle away by the arm. Peter Cano. Mr. Cano was Lyle's uncle, married to Kitty's sister, Marta's husband, and Annie's father, I believe. So Peter testified that when Lyle was 5 years old, he saw Jose take a full punch at Lyle, hitting him in the chest when Mr. Cano gave Jose a piece of his mind. Jose told him he would raise his sons as he saw fit and that Peter Cano could just leave. Mr. Cano did leave and never again returned to the Menendez home. Marianne Cano. Marianne is another cousin who stayed with the Menendez family over a vacation. She testified to Jose humiliating, mocking, and belittling Erik and Lyle. She was so uncomfortable she refused to stay at the Menendez home any longer. Jessica Goldsmith. Ms. Goldsmith testified that when visiting the Menendez home when Lyle was 9, he was climbing on the staircase, hanging from it, and became scared. When he asked Jose to help him down, Jose told Lyle to stay up there until you learn to be a man. When Lyle began to cry, Jose punched him in the stomach and told him to learn not to cry. Andy Cano. Andy was a cousin and friend of Erik's. Andy testified that when Erik was 12 or 13 years old, Erik told him that Jose was giving him massages in the genital area and massaging his penis. Erik asked Andy if his father did the same thing and swore him to secrecy. And remember, all of those people testified in the first trial, but not the second trial. And that's not even including all of the expert witnesses that deal with childhood trauma that testified for weeks and gave us such really good, in depth information about what the actual effects of trauma are. And they weren't allowed at the second trial, which I think is just a total injustice and horrible for the boys. All right, so during closing arguments, hold on, I just realized I was not plugged in here. I'm gonna make sure I don't run out of battery. All right, so during closing arguments at the first trial, the prosecutor urged jurors to find that no SA had occurred. In light of the evidence presented and recognizing that there was evidence which, if believed and corroborated the SA claim, the prosecutor alternatively argued that the A made no difference. The prosecutor told jurors, if you believe the SA that happened, that does not mean the defendants are not guilty of homicide because they are two separate things. But not really. I mean, they are, yes, but it is an effect. It's a side effect of the trauma, which is a key component to this that was not discussed at the second trial. And these are things coming from the prosecutor's mouth. We do not execute child molesters in California, and these defendants cannot execute them either. And vigilantism is something we cannot tolerate because then what happens? What if you decide your neighbor is a child molester and you go take your neighbor out? In light of the evidence presented, Lyle Menendez's jury at the first trial were hung on all three counts. As to the count one homicide charge with respect to Jose Menendez, jurors were hung 6 for voluntary manslaughter, 3 for second degree homicide, and 3 for first degree homicide. As to the count two homicide charge with respect to Kitty Menendez, jurors were hung 5 votes for voluntary manslaughter, 1 vote for involuntary manslaughter, 3 votes for second degree homicide, and 3 votes for first degree. As to the 3 conspiracy charges, there were 6 votes for acquittal, 3 votes for conspiracy to commit second degree homicide, and 3 votes for conspiracy to commit first degree homicide. Well, you gave them way too many options there, first of all. If you want an actual decision by 12 people to come together and give you one decision, you're giving them too many charges to go through. Is it first degree, second degree, or manslaughter, or involuntary or voluntary? It's just way too many. All right. So, my opinion. In light of the evidence presented, Erik Menendez's jury was also hung on all 3 counts. As to the count one homicide charge with respect to Jose Menendez, jurors were hung 6 for voluntary manslaughter, 1 for second degree homicide, and 5 for first degree. As to the count two charge with respect to Kitty, jurors were hung 4 votes for voluntary manslaughter, 3 votes for second degree, and 5 votes for first degree. As to the count three conspiracy charge, there were 6 votes for acquittal, 1 vote for conspiracy to commit second degree homicide, and 5 votes for conspiracy to commit first degree homicide. So that was a breakdown of how all of the jurors voted. At the second trial, there was only one jury for the 2 defendants. At the second trial, the court excluded substantial amounts of defense evidence, including the above described testimony from Diane Vandermolen, Peter Cano, Mary Ann Cano, and Jessica Goldsmith. In addition, the court excluded evidence of an essay Lyle wrote for school in 1982 entitled "I Will Change Your Verdict," about a man who was put on death row for taking the life of another man who had essayed his 12-year-old son. Interesting choice. In light of the evidence excluded at the second trial, the prosecutor doubled down on the position that no abuse occurred. The prosecutor argued the A allegations in this case were a total fabrication. There was no way of corroborating these allegations, which is completely and utterly false because there's so much corroborating evidence for this case. This is like this case has probably the most corroborating evidence of all SA cases. This one has so much corroborating evidence that it is so impossible. Like, it was never even refuted. I want that to be clear that it was never refuted other than by the prosecutor, but it was never refuted by any witnesses, expert or otherwise, at the trial to say that this never happened. Everyone that they put on, as you know, when we watched the trial, there was nobody that could say a good word about Jose. And it shows, I mean, there was so much collaboration, but whatever. All right, continuing on. The A never happened. There is no corroboration of SA. The allegations of physical and SA are not corroborated. Jose Menendez was not the kind of man that would be A-ing his sons. Instead, he was restrained and forgiving. He was not a violent and brutal man. And they said straight out that Andy was lying. Andy was not lying, and we know that now because we have the letter. Andy knew. Proof that Andy knew. And proof that Erik was talking about it with Andy. So the jury at the second trial convicted both petitioners as charged. In evaluating the prosecutor's position that the A never happened and that Andy Cano was lying, jurors never heard One, in December 1988, Eric Menendez wrote a letter to his cousin Andy Cano. The first the letter first describes a company party held at the Menendez home for the holidays. In the letter, Eric writes, "At times I wish I could talk to her," his mom, "about things, someday, especially dad and but the way that she worships him and tells him everything, I am so afraid she'll tell him whatever I say. I just can't risk it." So that is proof that he can't trust his mother. There's no trust in that household. There's no protection in that household. He has no one to go to. "It's still happening, Andy, but it's worse for me now. I can't explain it. He's so overweight, I can't stand to see him. I never know when it's going to happen again, and it's driving me crazy. Every night I stay up thinking he might come in. I need to put it out of my mind. I know what you said before, but I'm afraid. You just don't know my dad like I do. He's crazy. He's warned me 100 times about telling anyone, especially Lyle. Am I a serious wumpus? I don't know I'll make it. I I don't know if I'll make it through this. I can handle it, Andy. I need to stop thinking about it." So that was part of Exhibit 3. Andy Cano died from a drug overdose in 2003. Andy's mother, Marta Cano, provided a copy of the letter to journalist Robert Rand in April 2018. So this is well after their 1998 appeals when this letter was found. So many, many years later. All right. So Mr. Rand provided the letter to Mr. Menendez's former appellate counsel, who last represented Mr. Menendez in 2005 in April 2018. All right. In evaluating the prosecutor's argument that Jose was not a violent and brutal man and not that kind of man that would aid children, jurors never knew that in 1984, Jose, who was an executive at RCA Records, anally ard 14-year-old Stephen Roy Rosello Diaz, a member of the Latin boy group Menudo. Specifically, jurors never heard that Menudo was a Latin boys band formed in 1977 by music producer Ed- Eduardo Diaz. In the fall of 1983, Menudo signed a multi-year deal with RCA Records. At the time, Jose Menendez was an executive at RCA. In 1983, 13-year-old Roy Rosello joined the group. In the fall of 1983 or 1984, Menudo was appearing in New York City. During the trip to New York, Eduardo Diaz asked Roy to do a favor, instructing him to go downstairs at the hotel and join Jose Menendez in a limousine. Roy did so and was taken to a home in New Jersey, given wine by Jose Menendez and anally ard. Roy lost consciousness and woke up back in his hotel. He was bleeding from the anus. He was in unbearable pain for a week. Jose Menendez orally copulated Roy in a bathroom prior to a Menudo concert in New York. Later that same night, Jose Menendez anally ard Roy in a hotel room in New York City. That's all coming from a declaration from Roy Rosello, which we will read through in its entirety in part 2. Had jurors seen the letter that Eric Menendez wrote to Andy Cano and learned that Jose Menendez anally ard and orally copulated a 13 or 14-year-old boy in 1984, the prosecutor would not have been able to argue that the A never happened. There is no corroboration of SA. Jose Menendez was not the kind of man that would A children and was not a violent and brutal man. They wouldn't be able to argue any of those things, which ended up, possibly potentially swaying a jury. Timeliness allegations. Generally, courts will not address the merits of habeas petitions filed with substantial, unexplained delay. The following factual allegations show this petition is properly before the court. Lyle and Erik Menendez are indigent. Can never say that word. That just means that they don't have money. So all that money that they were supposedly did these crimes for, all gone because they had to defend themselves. I think most of it was gone even before they finished the first trial, to be honest. The defense for a trial that lasted 6 months, I mean, gosh, it's got to be a lot. All right, anyways, so they're indigent. In 1996, they were each given appointed counsel pursuant to the appellate court's indigent appointment process. Petitioners have been and are without funds to perform any habeas investigation. In 2015, Erik and Lyle heard about the letter that Erik had written to Andy Cano through a Barbara Walters special. We talked about her in one of my other shows that we streamed, Barbara Walters doing the questioning for them in, they were being interviewed in prison. That was their like first interview right before they were sentenced. They had just been, I think, found guilty, or yeah, they had just been found guilty, but they haven't been sentenced yet. And Barbara Walters came to the prison that they were at and filmed a special, and we went through that on my channel. So, anyways, this is how they found out that this letter existed. This Andy letter was on a Barbara Walters special that said the letter had been offered at trial but excluded by the trial judge. I don't know if that's not even true because the letter wasn't even found until way later. So beginning in 2018, Erik and Lyle learned that their trial lawyers could not recall ever seeing such a letter. Yeah, exactly. They were advised to obtain a copy. In 2018, journalist Robert Rand provided a copy of the Andy Cano letter to Cliff Gardner, Lyle Menendez's former appointed appellate counsel. Mr. Gardner did not recall ever seeing this letter before, but because Mr. Gardner had not actually reviewed the trial transcripts in so many years, he advised petitioners to review the trial transcripts to see if the Andy Cano letter was new evidence or whether instead it had been offered and excluded as the 2015 Barbara Walters special had indicated. So, was she right or not? At this point in 2018, neither Erik nor Lyle had copies of the transcripts at trial. In late 2020, Court TV posted on its website a transcript of the second trial and a video of the first. All right, good. So that's where I'll get the second trial transcript. With assistance from their family, petitioners were able to determine that the letter had not been offered and excluded at either trial. All right, so this is brand new evidence. They're proving this did not come into trial. There was some confusion about it, but we confirmed it. It never did. At that point in 2020, transcriptions of interviews with potential witnesses were still being transcribed. In November of 2022, Gardner learned that during an interview for a documentary, Roy Rossello, a member of the boy band Menudo, had admitted that he had been AR'd by Jose Menendez. Mr. Rossello provided a signed declaration in April 2023. This petition is being filed within 5 months of obtaining Mr. Rossello's declaration. And wherefore petitioners pray that this court take judicial notice of the transcripts and court records in People versus Menendez, Los Angeles Superior Court, and People versus Menendez Court of Appeals case. Order respondent to file and serve a copy of the record on appeal. After full consideration of the issues raised in the petition and the factual allegations of the petition and supporting memorandum, issue an order to show cause requiring the state to show cause why relief should not be granted. After the state files an answer and petitioners file a traverse, vacate the judgment and sentence imposed upon petitioners in the alternative, depending on whether the state denies material factual allegations of the petition, permit discovery and an evidentiary hearing at which petitioners may offer proof concerning the allegations of the petition which have been placed in dispute, and grant such other and further relief as may be appropriate. I think the mailman just dropped something off. So that is the end of their petition. Hold on one second. Do you guys have dogs that'll just continuously bark until you yell at them? Because that is my dogs. They'll just keep going until you yell at them. All right, anyways. So that is the end of their petition for a writ of habeas corpus, meaning they want a judge to look at their sentencing. They believe that their sentence is unfair due to the fact that there was this additional evidence that never came in, and they think that, it might change their conviction, it might change their sentence, so they want this reviewed by a higher court or the appellate court. So this is the response. We're going to go through, like I said, we're going to go through all of the exhibits in part 2, but really quick, we're going to go through the response from George Gascon's office. This is the current district attorney of Los Angeles County. He unfortunately lost his bid for DA for the upcoming term. Fortunately or unfortunately, I don't have anything, any feelings about him one way or the other than I'm all for the brothers coming out of prison, and I was hoping he would win for that, but that's the only thing. So I have no political ties to him whatsoever. Just I wanted to see him bring this to an end. However, because he did not win his bid for reelection, there is a new Hockman. Nathan Hockman is coming in, and he will be deciding if he's going to resentence this case or not. But why they couldn't have, the current DA, because he's on his way out, like I think December 8th. So why he couldn't have done more in this other than let's just ask for more time. He could have really like done a much better write-up of why he believes that they should be out or something. I don't know. Kind of disappointed in his response, but here goes from his office, anyways. This is the Superior Court of the State of California, County of Los Angeles. To the Honorable William C. Ryan, Judge, Department 100, Ritz Center, Central District, and to petitioners Erik and Joseph Lyle Menendez, through their attorneys of record Cliff Gardner and Mark Garagos. On May 3rd, 2023, petitioners Erik and Joseph Lyle Menendez filed a petition for writ of habeas corpus in Los Angeles County Superior Court. On June 15th, 2023, this honorable court requested that respondent file an informal response to the habeas corpus petition within 15 days of the order. Subsequently, this court extended the filing deadline, which is currently set for November 26th. They were supposed to provide a response November 26th to the habeas corpus petition. This is their response. They want more time. The people of the state of California, real party in interest in the above entitled case by their counsel, George Gascon, District Attorney of Los Angeles County, hereby request an extension of time up to and including December 20th to file the informal response. This request is based upon the attached declaration of Amy Wilton, the attached points and authorities, and all records of this case filed within the court herein. So this is, I don't know who Amy Wilton is. She's the deputy district attorney, so maybe because George Gascon is leaving, maybe she's going to help try to see this through. I'm hoping she'll stay on it and stay on Nathan Hockman, although he doesn't want them out. There's really not a whole lot that we can do about it. So, points and authorities. The court may extend time to file a return or an informal response on habeas corpus. Penal Code Section 1484 provides an intermittent part that in a habeas proceeding, the court has full power and authority to do and perform all other acts and things necessary to a full and fair hearing and determination of the case. The California Rules of Court, Rule 4.551, provides on motion of any party or on the court's own motion for good cause stated in the order, the court may shorten or extend the time for doing any act under this rule. So basically like a catch-all rule. In a minute order dated June 15th, 2023, this honorable court requested that respondent file an informal response to the habeas corpus petition filed by petitioners on May 3rd of 2023. This court ordered respondent to file the informal response within 15 days of the order. On June 27th, 2023, this court granted the respondent's extension request to September 25th, 2023. On September 25th, 2023, this court granted the respondent's extension be request to November 27th, 2023. So, okay, I'm not going to read all this. It just keeps getting extended, extended, extended. Why do we keep extending it? I think at this point this has been excessive and the court should not extend it anymore. But that's just my opinion. This has been going on for over a year. For the reasons articulated in the attached declaration of Amy Wilton, respondent respectfully requests an extension of time up to and including December 20th, 2024 to file the informal response. I am an attorney at law licensed to practice in all courts of the state of Illinois or state of California, sorry, and my own state is showing the state of California and am employed as a deputy district attorney by the County of Los Angeles. I am the assistant head deputy of the habeas corpus litigation team. In its June 15th, 2023 order, the court requested that respondents file an informal response to petitioners Erik and Lyle habeas corpus petition that was filed in May. To assist the court in determining the petition's sufficiency, the court may request an informal response from the petitioner's custodian or the real party in interest. In the habeas corpus petition, petitioners challenge their underlying convictions with claims alleging newly discovered evidence. In support of their claims, petitioners proffer a letter that petitioners alleged petitioner Erik Menendez wrote to his cousin Andy Cano in 1988 regarding SA and a declaration reportedly from a witness alleging that he was SA'd by petitioner's father. Respondent is in the final stages of the briefing process and requests a short continuance to properly complete necessary pre-filing date edits to the informal response. On November 25th, where did I miss I don't see the footnote anywhere. Where did I miss the footnote? I don't know. I don't think it's that important. It's about the California rule that was renumbered. So I'm not going to read all that. All right. So the respondent is in the final stages of briefing process. On November 25th, 2024, respondent noticed petitioner's counsel of our intent to request this brief extension. Petitioner's counsel does not oppose this request. For the foregoing reasons, respondent requests an extension of time to and including December 20th, 2024 to file the informal response. I declare under penalty of perjury that the foregoing is true and correct. And that is the Amy Wilton that is signed. And then she also says, I, the undersigned, hereby declare under penalty and perjury that the following is true and correct. I'm over 18 years of age, not party in the cause of Erik Menendez and Joseph Lyle Menendez, blah, 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 blah. Okay, request to extend time to file informal response. And basically, this is just saying that it was copied to Mark Garagos and Cliff Gardner. And that is annoying that they are just extending it again and again and again. And at this point, when December 20th rolls around, the new DA is going to be in office. So what that means for the habeas petition habeas, what did I say? The habeas corpus petition whatever that means for that, it's kind of up in the air right now. I'm not really sure, but we will see. So December 20th, I don't know. The judge hasn't agreed to this, but I don't see why they won't because it wasn't opposed by the defense or by Erik and Lyle. So they will probably extend it to December 20th and we'll be hopefully getting a response then, although it doesn't appear like we will. How many times did they delay it? Jeez, Lou. So I'm not even counting, but this whole paragraph is just dates upon which it was extended, granted. It's like, do you guys want to argue this case, or are we just going to keep going and pushing it further and further down the calendar and waste taxpayers' dollars in the process? All right, so that is where I will leave you. I will get the part two done and ready for you guys for Thursday. So we'll go through all of the affidavits and the letter that Erik wrote in its entirety to his cousin Andy, and all other affidavits that are included as part of the exhibits for their habeas corpus. In addition to that, so we're still not done because I realized that there's also a separate petition for resentencing. So we'll go through that as well, which will be after we go through all the exhibits. So there's still going to be more stuff that we're going to go through. So just letting you guys know, like I said, I had planned on getting this episode ready for last week, Friday, but with the holiday and realizing that there was so much more documents that I had to sort through, I had to get it figured out. So, yeah, but I'm glad that there's more content that we can go through and look over this case a little more and try to understand it better. So, thank you guys so much for joining me. I appreciate you so much. And please, if you don't mind, hit the like button on your way out, and I will see you guys in the next one. Take care. Bye now.